will be basic legal knowledge that paralegal activities should possess. Mr. G.G. Arulpragasam, G.G. Arulpragasam, a senior lawyer who has earned respect among the people and fellow lawyers, has joined us to deliver this lecture. Mr. G.G. Arulpragasam, Attormey-at-Law, achieved first-class honors in all 3 years in his exams in law college, and in the final year he topped the batch. Mr. Arulpragasam, proud achiever of Sri Lalita Rajapaksa Award for Best Outstanding Student of his law exams. A.B. Kure Memorial Prize for the subject of civil procedure and pleadings. The first-class scholarship for the most distinguished student of the law college for the final year. The Challenge Shield Cup for his outstanding academic performance. In the year 1979, he was anonymously elected as the president of the Law College Christian Federation, and in the same year he contested and was elected as a junior treasurer of the Law Students Union. Mr. G.G. Arulpragasam enrolled as an attorney-at-law in the Supreme Court of the Democratic Socialist Republic of Sri Lanka on 26th of September 1980. He is a life member of Sri Lanka Bar Association, Colombo Law Society, and member of the International Bar Association. From the year 1980 up to 1994, he conducted lecture for the final year students of Sri Lanka Law College, and number of students who are studied under him are now holding a position at the FX course. Mr. Arulpragasam is active practice of 4 decades and performing his professional career as an instructing attorney as well as the counsel. He represented a number of sensational cases. Among them are namely the early years of 1980s famous case known as Hotel Galaxy versus Mercantile Credit, always in regard to interim injection. In that case, he appeared as a junior counsel to Dr. Colvin R.D. Silva, and also another well-known customary marriage case, namely Grantia Catherine Vijay versus Vijay. In this, he appeared as a junior counsel to Mr. Jacqueline Seneviratna, Attorney-at-Law, against Dr. Colvin R.D. Silva. In recent past cases, namely when Sunday Leader newspaper was banned by the former President Mrs. Chandrika Bandaranaike-Kumaratunga, Mr. Arulpragasam appeared for the Sunday Leader newspaper in the fundamental right case and succeeded. In addition to the above, he was involved in a number of public interest litigation, namely he appeared for Nallandamma Incumbent Revenue Kinyavala Palita to reduce the petrol price and also against the Air Lanka privatization. He also represented the Sri Lanka Bar Association in several cases. He also appeared recently in few sensational cases. Some of them are Satsco cases. He appeared for well over 1,500 students and Manor Courthouse stoning case. He appeared for the Manor District Judge against the Cabinet Minister Richard Padri. He handled Dr. Samita Samanmali's case, who has sued BMHCH for incident took place at BMSH a few years ago and got judgment of rupees 108 million together with 5 years in legal interest. This is a landmark judgment in regard to damages cases. Now he is handling this Chela Priyadarshini's case, who is a lawyer and whose left arm was amputed above the elbow due to the negligence of the doctors and the staff of Mathara Central General Hospital. He was appointed as a member of the Law Commission of Sri Lanka by His Excellence the President on 24th March 2015. He was also appointed as an overall chairman of the Professional Purpose Committee appointed by the Bar Association of Sri Lanka to look into the disciplinary misconduct of lawyers, and His Lordship Honorable Chief Justice appointed him as a chairman of the disciplinary panel to inquire into the conduct of the lawyers. He was appointed by the Ministry of Justice as a member of Civil Procedure Code Amendment Committee, headed by his Lordship former Chief Justice Prasad Depp, Peace President's Council, and presently headed by His Lordship Justice Priyantha Javakara, President's Council. Mr. G.G. Arulpragasam was appointed by the Minister of Justice, Honorable Ali Sabri, President's Council, as a chairman of the advisory committee to look into the amendments to various ordinances and acts, and more particularly to review notaries ordinance, power of attorneys ordinance, wills ordinance, registration of documents ordinance, and renovation of irrevocable deeds of gift, and on the ground of cross Integrate Act number 5 of 2017. Honorable Minister of Justice Dr. Vijaydas Abade, President's Council, recently appointed Mr. G.G. Arulpragasam as a member to the committee, revised the bills of exchequer. Moreover, Mr. Arulpragasam took part of many of bar association of certificate courses, as well as the webinars, seminars. He was a well-known resource person among the lawyers. Over to you, sir.
Thank you, Prabha. Good evening to all of you. The topic that I will address you today: basic legal knowledge a paralegal activity should possess. So, just to structure my lecture, I just went into I just googled to see what is the meaning of a paralegal. So, the paralegal, the definition given is, paralegal is a legal professional who works under the supervision of a lawyer and perform tasks such as legal research, drafting legal documents, and assisting with clients and communication. So although whoever participating or listening to this lecture are not really lawyers per se, and also not taken oath as in the Supreme Court, I am going to address you on the basis as you have to basically assist the lawyers. I am addressing you as I am addressing to lawyers. So today the topic that I have structured mainly the practical side of the civil litigation. Under the topic that I am going to discuss mainly the matters that a lawyer should take into account when drafting the plaint, petition, answer and objection. So when a client come and retain you to draft a claim or file action against a particular defendant or defendants, what steps that you should take? Basically, the first thing that you have to look at is where is the jurisdiction, where you have to file action. So when you talk about the jurisdiction, the first step is that you have to see how the jurisdiction is emanating from. So when you talk about the jurisdiction, in the Civil Procedure Code, jurisdiction has been set out in section 9 of the Civil Procedure Code. For your convenience, I just read section 9 of the CPC. Subject to the pecuniary or other limitation of prescribed by any law, action shall be instituted in the court within the local limits of jurisdiction A party defendant reside, or the land in respect of which the action is brought lies or situate in whole or part. Number 3, cause of action arises or contracts ought to be enforced. So basically, as per the section 9 of the Civil Procedure Code, jurisdictions in twofold. You can file action A, where the defendant reside, or where the cause of action arose, or where the contracts ought to be enforced. If it's a land matter, where the land is situated. That is in regard to the civil actions are there. Then the other issue is, having said that is the civil the jurisdiction in terms of section 9, time to time, the Minister of Justice could either expand or combine the jurisdiction. For example, recently, where Mount Lania as well as Gangodavila courts has a parallel jurisdiction. So those are jurisdiction due to either pecuniary or some other way, it can be time to time minister could change. That is in regard to the jurisdiction. We are talking about section 9 of the Civil Procedure Code. Now the next question comes out. Matrimonial action in regard to the matrimonial cases or rather divorce cases, the jurisdiction section 9 will not apply. Why? There is a specific section in regard to the jurisdiction. What is the section? Section 597, 1 of the Civil Procedure Code, which categorically states where the action could file. It says very clearly, I will read for your convenience, section 597, subparagraph 1, which says, any husband or wife may present a claim to the district court within the local limits of the jurisdiction which he or she, as the case may be, reside. So the fact is, as far as the divorce actions are concerned, the section 9 will not apply. What will apply? The section 597, subparagraph 1 of the Civil Procedure Code, which categorically states you can file action where the husband or the wife reside. Now the question will arise whether the Sri Lankan court has jurisdiction to institute action when a party has contracted a marriage outside the country. I'll post the question again. Very often, we come across clients who come and seek our advice. They say, sir or madam, I got married in India. Whether there is any possibility, there is a matrimonial dispute. My husband is an Indian. I am a Sri Lankan citizen. Now I am back in Sri Lanka. My husband still lives in India. Whether there is any possibility to annul or to get a divorce in regard to a marriage which was contracted outside the country. So in fact, the case on the point is 1994 1 SLR 413. I'll repeat it again, you can take it down. 1994 1 SLR 413 Asokan versus Asokan. Now in this case, in fact, interestingly, High IU appeared in this case in the district court and I lost the case there in the district court, but subsequently the matter went in appeal and I succeeded. The facts of this case are, a Sri Lankan lady got married to a person who is an Indian national in India. Then they came back to Sri Lanka and they want to get a divorce. The question arose whether Sri Lankan court, this is 1994 I am talking, whether the Sri Lankan court had jurisdiction to dissolve a marriage which was contracted outside the country. So, as at that time, the law prevailed was, there was a case called 1 NLR 160 Lemasuria versus Lemasuria, because prior to this Civil Procedure Code came into operation in terms of the General Marriage Ordinance, where the provision was the divorce can be dissolved, marriages can be dissolved only if that particular marriage contracted in the Sri Lanka, not outside Sri Lanka. So, in Lemasuria versus Lemasuria case, 1 NLR 160, where parties were living in Mahatara, they filed action to dissolve a marriage which took place in England. But court held, Sri Lankan court has only territorial jurisdiction and therefore a marriage took place outside the country cannot be dissolved. For the reason because as at 1 NLR 160 came, the Civil Procedure Code section 597 subparagraph 1 was not in operation. So going on that old case of 1 NLR 160, the learned district judge dismissed my case. The matter went in appeal. So when the matter went in appeal, court did not basically overrule, distinguished the judgment and said 1 NLR 160 is a right judgment as at that time. Now the law has changed. In terms of the new law, in section 597, subparagraph 1 of the Civil Procedure Code, if either husband or wife resides one of the jurisdiction in locally, the marriage can be dissolved. That's the latest law. Now, just any client come and seek your advice and say marriage contracted outside the country, whether it could be dissolved, answer is yes. Now, similarly, another very serious burning issue where other way, vice versa, where a marriage has been contracted outside the country. Not marriage, the divorce has been granted outside the country, whether Sri Lankan court will recognize. So all this time, up to very recently, the position was no, answer is no. Marriages which was contracted outside the, divorce which was granted outside the country was not recognized and Sri Lankan court refused to accept foreign judgments and said you have to file action in Sri Lanka to get a divorce. Foreign divorces are not recognized. It was a very burning issue because people who live in UK, USA, Canada, London, Australia, after a hard battle, they get the divorce. Having got the divorce, when they come to get married in Sri Lanka, or some of the instances where having got the divorce, they have even contracted another marriage in that country, where the Sri Lankan court still doesn't recognize the foreign country divorces. So, in fact, there was an act brought in, and still it's in the bill stage, not passed. But fortunately, very recently, it's about on the 1st of December, basically about 12 days ago, there was a judgment of the Court of Appeal where they held in a writ application. I'll give the number, CA writ 266/2021. I'll repeat it again. CA writ 266/21. Parties are Lienage Champika Harendra Silva versus Registrar General. Similar situation in this case too, where marriage was the marriage was dissolved outside the country, and in Sri Lanka they refused to recognize that particular dissolution of marriage, and Registrar General refused to register the marriage in Sri Lanka. So, in this case, court held that if a divorce granted in a foreign country, there are three limbs are there. Important thing is, first and foremost, in terms of that law, in terms of the country, that law, there must be a proper dissolution of marriage. That is first requirement. Second thing, the parties should be living in that particular country for a reasonable period of time. The third thing, it should not be an ex parte order, it should be an inter parte order. To basically, to come back to the situation there, foreign divorces are granted in a foreign country, accepted. Similarly, as I said earlier, Asogan versus Asogan case, where marriage contracted outside the country too could be dissolved in this country. That is in regard to matrimonial matters. We are talking about still jurisdiction. Then the next one, the third point is in regard to testamentary action. When you file testamentary action, testamentary action can be filed jurisdiction either where the death took place, or where the petitioner resides, or the property fully or part situated. So if it's happened to be a testamentary case pertaining to a last will, from the date of the demise, the last will has to be approved within a period of 3 months. In regard to if there is no will, action has to be filed within a period of 1 month. So that is the third one. Then the fourth one, in regard to jurisdiction, commercial transaction. Now when you say commercial transaction, as I told you earlier, time to time, Minister of Justice can change the monetary value. Here again, now the latest thing is, if any commercial transaction value of a particular case is above 50 million, you can file action in the commercial high court. You can file action in the commercial high court. In regard to apart from that commercial matter, there are in the Act of 10 of 1996 Commercial Court Act, where the schedule has been specified. What are the action could be filed? So the cases coming under the ambit of Commercial High Court are any matters pertaining to Act number 7 of 2007 Companies Act. Basically, winding up application, dispute between directors and shareholders, all that matters comes up under the Commercial High Court. So that is that one. Then the next one is in regard to the check matter, liquid claims under section 703 of the Civil Procedure Code. Those cases too fall into a different category of jurisdiction. What is the jurisdiction there? The jurisdiction there is where the check bounce, we use the terminology, debtor seeks the creditor. So where the check dishonored only, you can file action. So you could see in regard to as I told now, back again, I go back to the original thing there. When a client comes and consult you where to file a case, if you are drafting a plan, you have to look into these matters. What are the matters you have to look into? Number one, in terms of section 9 of the Civil Procedure Code, where the jurisdiction, either where if it's happened to be contracts ought to be enforced, or cause of action arose, or where the land is situated, or the defendant reside. That is in regard to first matter. In regard to matrimonial matters, in terms of section 597, subparagraph 1, you can file action where either plaintiff resides or the defendant resides, one of the two. Then again I gave you two judgments. The first judgment, Asokan versus Asokan. In terms of that judgment, our court held that any marriage contracted outside the country could be dissolved in Sri Lanka. What is the basis? Section 597, subparagraph 1, jurisdiction. Similarly, I gave you the latest judgment is there, CA writ 266 2021. In that case, where court held that any divorce, basically we call a foreign divorce, any divorce granted in a foreign country will be accepted in our country as a valid divorce under 3 that country. Number 2, the party should have been living for a considerable period of time in that particular country. Third thing, it has to be an inter parte, it can't be an ex parte. That is in regard to matrimonial matter. Next one, in regard to testamentary cases. Testamentary case jurisdictions are where the petitioner resides, death took place, or where the property partly or fully situated. Then if it's happened to be a last will case, within a period of 3 months, if there is no will, within a period of 1 month. Now in regard to commercial transaction, I told you in the particular Act number 10 of 1996, there is a schedule. What are the cases falling within the ambit of commercial high court? By a recent gazette notification, the value of the matrimonial value has been, monetary value has been increased. Any particular commercial transaction, value is above 50 million, then you have to file action in the commercial high court. Addition to that, any cases falling under the Companies Act 7 of 2007. For example, dispute between directors and shareholders, winding up application, all that are falling under that. Then the next item is in regard to liquid claims, checks, pro note, bill of lading, all that matters. If you are filing any action, that the law is there, debtor seek the creditor, where the check bounce. Now all these things I said it under the jurisdiction there. Now similarly, so when you are drafting a plaint, when you are drafting a petition, you have to look into this. On the other hand, if you are drafting an answer, if you are drafting or taking up a statement of objection, you can take up these objections provided it doesn't fall within the, now for example, if a divorce action filed, now there are instances, certain councils, they file divorce cases for their convenience. Now say for example, you come and retain a counsel in Colombo, and then the parties are living outside the jurisdiction of Colombo. The lawyer says, no, it's very convenient to me, shall you file action in Colombo because it's easy for me. Finally, that if such action is filed, if you know very well either the plaintiff or the defendant not resigning, you can take up the objection, get the action dismissed. Similarly, all other matters are same. So you have to, if you are a plaintiff, look into the jurisdiction correctly when drafting the plaint. If you are for the defendant, go through this jurisdiction procedure and see whether that is falling within that category. Not falling, then you can take objection, you can dismiss. So the first point, all this time I dealt with in regard to the jurisdiction. That's the first thing is jurisdiction. Now the second matter that what you have to look into is cause of action. What do you mean by cause of action? Cause of action means what is the basis the case has been designed. Now say for example, if it's a divorce action. It's a divorce action, section 19 subparagraph 2 of the General Marriage Ordinance is categorically says you can get divorce only three grounds. Either it's first thing malicious desertion. It can be malicious desertion per se, or it could be constructive malicious desertion. That's the second. The second one is incurable impotency. Incurable impotency there. So if the one is a malicious desertion, incurable impotency, those are the grounds where you can get the divorce. Now the next question arises, desertion there. Now the next, or adultery after the marriage. Now there are instances where the lawyers, when they draft plaint, you can see very juicy, interesting plaint. The plaintiff will say the X and Y met, they had a love affair, or what and what hotels or places they visited, all the details, unwanted details will be there on the plane. There won't be any cause of action. When did he desert? What happened? So starting from the honeymoon night up to the date of the dispute, they will come, but they won't tell when did the desertion took place, whether it's a constructive desertion or a malicious desertion. Now, the difference between malicious desertion and constructive, malicious desertion is that you left the matrimonial home and went, that you call a malicious desertion. Constructive malicious desertion, you make your partner miserable to stay with you and you were compelled to stay. That is what you call a constructive malicious desertion. So I have come across many planes where the entire, as I told you, very juicy to read, starting from the thing, is a proposal or affair, where and where they went, what and what hotel they visited, what happened in the first night, how dispute arose, how he hammered, or went to the police, all that. But they won't set out, most of the planes won't set out the date of the desertion. If the date of the desertion is not there, there is no cause of action. The action can get dismissed. Now they are again recently talking about this prolix or this kind of there. So because section 46 subparagraph 1 of the Civil Procedure Code categorically says that if your plane is not in order, the action could be dismissed. So read it, section 46 subparagraph 1. Yeah, say 46 subparagraph 2. Before the plane, there is it. Court can refuse to entertain if it does not state correctly without prolixity the several particulars herein before required to be specified. If contains in particular other than those are required, then it does not disclose a cause of action. It is not there. Then it is wrongly framed, misjoined and non-joined. So section 46 subparagraph 2 categorically say when you draft a plane, you have to set out the cause of action correctly. You have to join the correct parties, do the thing. So I just took the example of a divorce. If it is a divorce, you have to categorically state what cause of action, whether it is a desertion, whether it is a malicious desertion or a constructive desertion. With adultery, now even in regard to adultery, I come across many planes talking about the history. Prior to the marriage, he had so many affairs, lived with so and so, have a child. So you knew all that. You knowing very well you get married. Thereafter, you can't come out with the history of that man or woman and ask for a divorce. Why? Cause of action, section 19 subparagraph 2 of the General Marriage Ordinance, adultery after the marriage. Then in regard to the impotency also, incurable impotency. There are men, where I say impotency, there are people, it should be incurable. If it's curable, it's not there. There are instances I know, some of the parents hide the fact that the son is an impotent man and give it in marriage, thinking that after the marriage, he will get this defect cured. I think what I could see is finally the woman also will become impotent. So the fact is that this kind of, when you draft a plane, you have to be very cautious. Correct cause of action has to be done. Now the next question, talking about the divorce. Now some of the lawyers who used to think mere 7 years separation is a ground for divorce. No. If you look at the Tennecone versus Tennecone judgment, what they held is in regard to the procedure. As far as Sri Lanka, now I saw a few days ago in the paper, now to get divorce process quick because it's getting dragged on, there is a no-fault divorce has been introduced in addition to the present ground. That means if the marriage is broken, if they can't live together after a particular considerable period, you need not have any ground for divorce. They know, I think in UK it has been recognized after a period of particular period that you live separation. If the parties can't get together, you can say marriage is completely broken off, you can't do, then you get the divorce. Similarly, in Sri Lanka also, without averring any ground, they are going to go for no fault divorce. The law has not become, I read in the papers maybe Sunday, it was in the headline, no fault divorce, so the process is going to change. So talking about a cause of action, what is important, you must exactly aver what is the cause of action. Then I said about this 7 years separation, some of these lawyers of the view, 7 years separation is a ground for divorce. No. Tennecone versus Tennecone case, what court held was, it is easy process of divorce. If a party is separated for 7 years, they can file, than filing a normal plain affidavit, normal plain, what they could do is they can have a petition, they can file a petition, affidavit, and set out that 7 years they were separated. If the defendant or the respondent concedes that 7 years they were not living together, they had nothing to do with each other, that, and if he come and consent, you can make the degree nisi, the order what has been made by the order nisi absolute. So the basically Tennacone versus Tennacone, or a 7 years separation, we call it in Latin term mensa et thoro. So living in separation, they are not having any sexual relationship, not there for a period of 7 years, is a ground, is not a ground for divorce. So if you go on the basis of 7 years separation, in addition to the 7 years separation, as per Tennacone versus Tennacone, you have to prove matrimonial fault, either divorce, constructive, or the malicious, adultery after the marriage, or incurable impotence. So 7 years separation is not a ground for divorce. So that is in regard to the cause of action. The third thing is, now I said about jurisdiction, you have to be careful. Number 2, you have to be careful with the cause of action. Number 3, you have to identify the defendant. When you are filing an action, you have to identify the person by, there are various ways you could file action. Number 1, there may be instance where you have to file an action against an individual. So if you are filing an action, there is no problem. Name that person, put his address, filing action is correct. Now if you are filing an action against a sole proprietor, you have to say Mr. X carrying on business under the name and style and firm of sole proprietorship. If somebody is running a business on a sole proprietorship, you simply name him and you file action, your action will get dismissed. Why? He is not a legal persona. He is not a legal person. So therefore, when you file action against a sole proprietor, you have to specify and say what is the sole proprietor, what. So the wording you have to put on the plaintiff is X, Mr. X, running on business under the name, style and firm of sole proprietorship such as their business has a particular name, you have to say so and so in such and such a name carrying on business. Similarly, if there are 2 or more partners running a business, you have to say X and Y running a business under the name, style and firm of, you have to put the details are there, otherwise the action is bad in no. Then the next one, when you file an action against a limited liability company, you have to name the company, and not against directors, you have to name the company and file action. Now in addition to that, there are instances, now 4 instances I have told, you have to identify the person against whom you file action. Now as I said, if you have filed action against a sole proprietor, naming him without putting the business name, your action can get dismissed. Similarly, if there is a partners, you put the 2 partners name, not putting the wording properly, carrying on business under the name, style, firm, or if you have not got the partnership seal, your action can get dismissed. Similarly, limited liability company. Now those are the, one is you have to be careful in regard to drafting paper. Similar objections can be taken up when you do not follow up this procedure. Now the next question arises, how will you file action when say you have to file action for and on behalf of the minor? Why? Minor can't enter into any contract. Minor cannot come to court or take any step. How do you do? Section 477 of the Civil Procedure Code says when a minor is a party, how do you file action? Section 477 of the Civil Procedure Code says every application to the court on behalf of the minor shall be made in his name by his next friend or his guardian for the action and shall be expressed to be made on the face of the bill. So now practically you have to understand how does it happen, practically how this particular thing happen. Now say for example, if X died and the surviving persons you want to file action, now there is a minor involved, minor too want to file a separate action, sue the person who made that accident and got the father to be killed. So the way that you could do is, first and foremost, if a minor going to be a plaintiff in the case, you have to file an action called a CG, curator guardian, or a action. So you have to draft the papers and say so and so is a minor, the minor's father died, what exactly narrate, he was the breadwinner in the family, he died and therefore now there is a necessity as a result to sue him to recover damages, and therefore he is a minor, and I request court to appoint so and so as a next friend for the purpose of the proceeding with the case. So in that particular CG case or a curator guardian case, you have to annex a copy of the proposed plain that you intend to file. So first step, you file action by way of a petition and affidavit, seeking permission, court, to appoint you or whoever the person as minor's next friend. So once he is appointed as a next friend, thereafter you have to file a fresh action and say so and so appearing by his next friend appointed in such and such a case and set out. That is when a minor is a party. Then similarly, when you file action against a club, or when you file action against an unincorporated body, or when you file action against a political party, what do you do? Because there are numerous people are there. So that's where section 16 of the Civil Procedure Code says, when you file action against an unincorporated body or numerous people are there, what steps to be taken? Where there are numerous parties having a common interest in bringing or defending an action, or one or more such parties may, with the permission of the court, sue or be sued, may defend in such action on behalf of all parties so interested. So what you do, say for example, against a political party. Now there is some person going to get got expelled or going to get expelled from a particular recognized political party. Now if you take a political party in Sri Lanka, there are, apart from the party chairman, secretary, there will be numerous people against whom to file action by unincorporated body or a club. So what do? You file a normal plaint. We are asking for an interim order or enjoining order, normal plaint, affidavit. Addition to that, in the same action, you will have a thing called a petition. What is the petition says? This particular plaintiff, defendant company or a defendant political party or defendant club is unincorporated. There are numerous members who has it. So therefore, to sue for and on behalf of that particular club whom to make the defendant, asking permission court to appoint the party chairman or a president and the secretary to be there. So the court will, before you support the application for an enjoining order or whatever the interim order, you ask for a court order first of all to allow you to make the particular chairman or the president and the secretary to be sued for and on behalf of that club or unincorporated body or the political party. Then court will allow. Once this is allowed, how do the defendant knows who has been allowed to be party? Court always say, publish in the newspaper. So English, Sinhala, Tamil, all three newspapers, this publication has to take place in regard to the who has been named to be a party to the foreign on behalf of the defendant, either unincorporated body or a club or the political party. Then it will appear in the newspapers. Addition to that, court also will make an order to go and affix in the notice board of that particular place. Now say some political party head office to be affixed. So back again I will tell you. Now first thing I spoke about jurisdiction. Second thing I said about cause of action. The third item is how to identify the defendant. So you have to be careful when you are filing action against individual. There is no issue. You know who the individual is. So you file action against that individual. The second, thereafter, if it's a sole proprietor, you have to say X running business under the name, style and firm of put whatever there. Then next one, if it's a partnership, you have to say so and so carrying on X and Y carrying on business under the name, style and firm of partnership such and so. If it's a limited liability company, then a limited liability company you have to name it. Then the next thing I said, in terms of section 477 of the Civil Procedure Code, if the action filed for and on behalf of the minor, you have to initially file a CG action, get yourself appointed as a next friend, then you must file action. Then in the caption, you have to specifically say, so and so minor appearing by next friend so and so. Similarly, when an unincorporated body such as a club or a limited liability company or a political party, then you have to file a section 16 of the Civil Procedure Code application and get a person to be appointed. So now I have discussed with you jurisdiction, cause of action, identify the defendant. So if you do not follow, when the other side filing the answer or when they are filing a statement of objection, they will take up the defense and dismiss your action. You have to be careful. Then the next one I am talking about prescription. Now when you talk about the prescription, every action, anything, any wrong thing happen, you can't just wait for a long, because there are time periods are specified. Within the specified time period, you have to file action. If you do not file action, we call in law is prescribed. It's prescribed. Now take about a prescription, for example, I just glance through there. There are certain cases with the lapse of time you can't institute action. For example, accident cases. Accident cases, the period is maximum 2 years. However serious it may be, gravity may be, if you are not taken within 2 years, it's completely prescribed. That is in regard to accident cases. In regard to goods sold and delivered, you can file action within a period of 1 year. After the 1 year, the period will completely lapse. You can't file any action. In regard to the land action, you can file action on undisturbed, uninterrupted possession, and if somebody is having uninterrupted there, will over 10 years. Say for example, your property, a thug will enter, forcibly stay, will over 10 years. You may be having 100 years old title deeds. Nothing can be done. Why? If that particular person forcibly entered could prove that he was there for uninterrupted, undisturbed possession for a period of well over 10 years, he will get the property. You will lose. Then similarly, if there is any breach of peace, such action in terms of the Primary Court Act, within 2 months from the date of the breach of peace took place, within 2 months you have to file action. Similarly, in regard to defamation cases, it's 2 years, not more. Then written contract, it is 6 years. Oral contract, it is 3 years. In regard to mortgage bond action, from the date of the mortgage bond, it is within a period of 10 years. But back again, the 10 years prescription can break. Assume for a moment that mortgage, say for example, mortgage was executed in 2010, now in 2023. In between, if he has made any payment, the prescription from the date of the last payment, not from the date of the bond. So if there is any mortgage bond and period is 10 years, it's true, but if there is any payment made in between, then that particular period prescription will break from the date of the last payment, 10 years. Then in regard to the checks, pro note, bill of lading, the period is 6 years. But in regard to presenting a check, now say for a check is written, if the check is not presented to the bank for the encashing, that will become a stale check. So prescription is 6 years, but to presentation to the bank within 6 months. Similarly, in regard to the filing testamentary action, in terms of section 545 of the Civil Procedure Code, the period but you can file a testamentary action will be 5 years. It was initially 20, now it has been amended to 5 years. Similarly, arrears of rent, 3 years, labour tribunal cases, 6 months, and possessory of action, 1 year. I'll quickly run through again in regard to the prescription ordinance. Prescriptions are concerned, as I said earlier, every matter, when you have civil dispute, the period is given there. Now, for example, you take over a case. You don't know your law properly. So, for example, accident case, after maybe 2.5 years, somebody come in to file an action. You don't look at the period, you file action. And then what happened? The client will sue you. Why? You never knew, at the time the client came, action is prescribed, you took his money, filed the action, other side took up a preliminary objection, case got dismissed. So you should be careful. So if you don't know your prescription ordinance, and you will get into major difficulties, but end of the day you have to face discipline inquiries. I'll just quickly run through prescription ordinance, take down if you are taking it down. Accident cases, 2 years. Accident cases, 2 years. Goods sold and delivered within a period of 1 year. Then land actions, 10 years. If somebody can prove undisturbed, uninterrupted possession for a period of well over 10 years, he will be the owner, even though he may be a trespasser or a thug or anyone, because that's law recognized. Then, in regard to Section 60, his application under the Primary Court Act, period is 2 months. Defamation actions, 2 years. Written contract, 6 years. Oral contract, 3 years. Mortgage bond, 10 years. Provided if there is any part payment made, prescription will run from the date of the part payment. Checks, pro note, bill of lading, period is 6 years. Then, however, presentation of check to present it to the bank, 6 months. Then, in terms of Section 545 of the Civil Procedure Code, the testamentary actions have to be instituted within a period of 5 years, otherwise we can't do, it will be prescribed. Arrears of rent, 3 years. Labour tribunal cases, 6 months. Possessory of action, 1 year. So that is the fourth point I said. First point, jurisdiction. Second point, cause of action. Third point is how to the jurisdiction, cause of action, identify the defendant. Next is the prescription ordinance. Now the next is what happens. Now you see, as I said, you have to be very careful with the prescription ordinance. If you don't know your prescription ordinance, your case will, other side can take up objection, case can get dismissed. So be cautious on that. Now the next issue is, when you are filing an action, what steps that you take if a state is a party? If a government is a party, what steps that you can take? So the step that you have to take, set out in Section 461 of the Civil Procedure Code, you have to give, prior to filing action, 1 month notice. I'll just read it to you, Section 461. No action shall be instituted against Attorney General as representing state, or against a minister, deputy minister, or public officer in respect of any act purporting to be done by him in his official capacity until the expiration of 1 month from the date of notice. Then next question arises. Alright, action 5. What will happen? Will that action get dismissed? Answer is no, because Section 461, subparagraph A, subparagraph 1 says, in case if any action is filed without notice to the Attorney General, in such event, action will not get dismissed. It will be laid by, or it will be stayed for a period of 1 month, and thereafter only steps will be taken. That's what Section 461, subparagraph 1A says. Where no notice required by Section 47 given to prior to the institution, objection is taken up, or answer no such notice has been given, the court shall stay further proceeding of the action for a period of 1 month, may order the plaintiff to pay defendant such costs. So, if anybody has, when a state is a party, if action has been filed, no 1 month notice has been given, in such event, where court could say, stay the action for a period of 1 month, for the lapse of the plaintiff's party, court can even order cost. So that is in regard to the state. Then next is whether the claim referred to a mediation board or not. Now in regard to the mediation board, earlier various amounts are there from very recent, somewhere in April 2023. Now there is a new gazette has been coming. According to the new gazette, if any value of the action is below 1 million, you have to go to the mediation board and obtain a certificate of non-settlement. You have made an application to the mediation board for settlement, other side is not settling, you have to get a document called certificate of non-settlement. Otherwise what happens, other side may take up the objection that certificate of non-settlement, the action can get dismissed. So certificate of non-settlement also needed prior to filing. Non-settlement is needed. If the certificate of non-settlement is not there, action can get dismissed. You have to be careful on that. Then talking about the jurisdiction, another one is relevant statute or act. So if you are filing an action based on a particular act, you have to say under what act or under what law that you are filing. Whether it is the Rent Act, Recovery of Possession Act, Companies Act, Land Alienation Act, or whatever the law, it has to be set out in the plaint. Then another crucial thing, very often we come across from recent past, in regard to the commercial transaction. So you see, when you are the commercial transaction, where say, especially say somebody X entering into a contract with Y to do a construction and sign MOU, and then what happens is there is a dispute between the parties. Between the parties there is a dispute. So when there is a dispute between the parties, now the parties are compelled to go to courts. So before going to court, you have to understand, you have to look at, check and see whether there is any bar in the agreement to go to court. Why? Very often, most of these commercial agreements pertaining to various transactions, there is an arbitration clause. What do you mean by arbitration clause? If there is any dispute between the parties, it is mandatory to refer to the arbitration. So what we call a ouster clause, where court has no power to look into the matter. Why? There is an arbitration clause. Now, when talking about arbitration clause, the famous cases you can take down 1987 1 SLR 5 Hotel Galaxy. Hotel Galaxy case, I'll give you the exact reference. 1987 1 SLR 5 Hotel Galaxy Private Limited versus Mercantile Hotel Management Limited. Now, in this case, what happened was Hotel Galaxy, they were the owners of the building, the hotel, they rented it out to Mercantile. So, Mercantile, they were using the premises, there was a dispute, they were physically thrown out of the premises. Then what happened was that the party who was occupying, who got ousted, went to magistrate court, sought an order. In the magistrate court order, where court said, at this juncture, I am refusing to grant an interim order. Then they came back to the district court, applied for an enjoining order, and they got an enjoining order. After they got an enjoining order, the plaintiff, back again, like the earlier case, this case too, I happen to be the lawyer who appeared in this case with Dr. Colina De Silva. Then what happened in this case also, then defendant took up the position that there is a suppression. What is the suppression? That they said they went to the magistrate court, they did not divulge the fact. They went before court, sought an interim order, and court refused to grant an interim order. So when we submitted to court, when we party on behalf of the Hotel Galaxy, we submitted to court that they have sought intervention of the magistrate court, tried to get an interim order and failed, and therefore there is a vital suppression. Therefore, the enjoining order should be vacated. Based on that submission, it was vacated. Then the other side, the appeal. In the appeal, what happened was, court held, yes, it's a suppression, but it's not a vital suppression, and they vacated the order. Went up in appeal. Unbelievable thing happened in the appeal. The judges looked, the area that we even our counsels also did not look into it. The Supreme Court judges looked into the matter and held, forget about suppression or any other matter, there is a vital issue. What is the vital issue? The agreement entered between Hotel Galaxy and Mercantile Investment Limited, there is a clause called arbitration clause, and therefore court had no jurisdiction to entertain the case. Based on that, the action got dismissed. So most crucial thing, when you advise a client in regard to a commercial transaction, look at the document and see whether there is any clause to the effect that there is an arbitration. If there is an arbitration, court has no jurisdiction. Now the next question will arise. While because arbitration process will take months or some days, can party go to, if there is any irreparable remedy, can a party go to court and get a enjoining order preventing? Now say for example, there is a X giving Y to do certain condominium transaction, construction, and then what happens is he defaults. Now he can't, because he is at the premises and he is doing various damages and not vacating the premises, doing anything. Now can you get a court order restraining him doing any wrongful act? Answer is yes, because there is a case on the point, Baxter versus Hyder Ali. In this case, it is an unreported judgment, CALA 51/97, Baxter Textile versus Hybro Industries. I'll give you the reference, CALA 51/97, Baxter Textiles versus Hybro Industries. In this case, court held while the arbitration proceedings are on, the district court has, relevant court, maybe district court or commercial high court, has power to grant interim orders while the process take place. So the point what I am trying to stress is, when you look into the matters, you have to see that there is an arbitration clause. If there is an arbitration clause, court has no power. In such event, when you draft the answer or objection, you can take up an objection that there is a particular arbitration clause, notwithstanding that they have taken it, and therefore action can get dismissed. Now these are the basic main things what a lawyer has to look into when a client come to get the advice. So I'll recap again couple of points. Number one, jurisdiction. I'm not going to do it in detail there. Number two, cause of action. Number three, identify the defendant. Number four, prescription ordinance. Number five, whether state is a party. Number six, whether claim refer to arbitration. Number six, what is the relevant act? It's a commercial transaction. Now the question is, practically what is happening is, now look at you can see practical process. Process is, you file an action in the district court. You can file a general action. If you file a general action not claiming any enjoining order or any kind of interim relief, procedure will be, a date will be given for summons to be served, answer will be filed, there can be replication, procedure will follow. Now what happens is, the second step, you have to get an enjoining order, restraining a wrongful act. So what do you do in such instance? So if you want to file action, get a interim order in regard to a wrongful act, then what you should do is, you have to file plaint, affidavit and connected document. Now say for example, as I said, somebody is doing a construction on your building to the adjoining land, and there is some cracks coming in your wall. Now how do you prevent? So you have to file a plaint, you have to file an affidavit, then you can get the photograph. If there is any kind of a structural engineer's report, you have to get the structural engineer's report. Addition to that, you may have to get, even if you have done any police statement there. So you have to prove prima facie that there is serious matter to be looked into. So the court will grant an enjoining order, restraining the other person doing the construction. So the couple of things court can do. Number one, court could grant an enjoining order in the first instance, restraining the other person doing any construction, damaging your wall, or only could give a notice of interim injunction there. Now next question is, there are certain instances where you having filed action, now say for example, rent and ejectment action you are filing. Having filed a rent and ejectment or a overholding lessee, you have filed action to eject the tenant from the premises. While the action is pending, you get the information, now the defendant is trying to sublet the premises. What can you do? Whether you can get any enjoining order? Yes, you could. So the position is that when the action is filed and you have got an enjoining order, you have filed action and the case is going on, and if you do get any information to the effect that he is going to do some continued wrongful act, you can file in the same action, petition, affidavit, and you can ask for a court order restraining the defendant renting out the premises. So those are the various steps that the defendant could, that the plaintiff should do in the first instance in regard to those cases. Now let's talk about the situation the other way. Now once the papers are filed, what can the defendant do? So now say for example that you have been served with the enjoining order and notice of interim injunction. What are the options that you have in regard to that? So now the options that you have is, number one, either you can keep quiet, come on the notice returnable date, tender a proxy and move for a date for answer. That is the first step. Now the summons have been served on you, notice of interim injunction served on you, enjoining order is served. If the enjoining order is not bothering you and it can take time, you simply file a proxy, move for a date to file answer and objection. But you have to be very careful. You have to move for a date for answer, or you must reserve the right to file the answer after the order delivered for application. There are many instances where I have come across, where I have taken the advantage to, lawyers are only coming and moving date for objection, not a date for answer. In a such situation, a motion can be filed and can get the case fixed to ex parte trial, and your client will get into difficulty. So that is the first step. The second step is, if you do feel on the face of it, now say for example, other side has got a court order and you fall into one of these categories. Say for example, there is an arbitration clause. Notwithstanding the arbitration clause, the plaintiff has got an enjoining order. Court should not have issued why court has no jurisdiction. So in such a situation, you need not file any paper. You can simply file a motion and bring to the notice of the court and say, here is the arbitration clause. According to the arbitration clause, court has no jurisdiction there. Then you can straight away can get the action dismissed there. So, or any one other ground. Now, say for example, as I said earlier, it is prescribed on the face of it. On the face of it, it's prescription. You fall into another. Then you can file a motion and bring to notice of the court. On the face of the plaint itself, this action cannot be maintained. This action cannot be maintained on the face of the plaint. So court can do that. That's the second thing. Third thing what you could do is you could file petition. You can file your statement of objection and also can object to the extension of the enjoining order. So because the enjoining orders are not extended for no rhyme or reason. The section says very clearly, once an enjoining order is issued, court can extend the enjoining order only for good, valid reasons only. So, notice reasonable aid in any case in regard to a notice of interim injunction is a very serious matter, because on that day anything can happen, because if the court is not satisfied that you have got the enjoining order by suppression material fact, ex moro court, according to the section says, section 664 subparagraph 2, ex moro motu, court can do on his own accord, or court can, on an application by party, court can vacate the order. Yeah. Section 664 subparagraph 3, the court may, of its own motion or on an application made by any party, suspend operation of any enjoining order issued under the, if it is satisfied, such order was obtained by suppression or misrepresentation of any material fact. So when an enjoining order is issued, court, that you can do three things, as I said earlier. Number one, if that enjoining order is not bothering you and is not there, you simply file a proxy on that day, move for a date to file answer and objection. That's the first step. As I said, you have to be very cautious on the returnable date, reserve the right to file answer after the order delivered. Otherwise, time to time make application to court, because if it is not recorded, other side can file a motion and ask for to fix it for ex parte trial. Number one. Number two, now the matters I set out earlier, like those preliminary objection issues, if the court has no jurisdiction, if there is no cause of action on the face of it, if the person identified wrongly, or if there is an arbitration clause, if it is a state involved. So on any of those occasions where you can file a motion and bring to the notice of the court, there is a clear arbitration clause, they are suppressed, court has no jurisdiction, and therefore court should not entertain. So without filing any papers, merely filing a proxy, you can ask for a not only vacate the order, even a dismissal of the action. That is the second step. The third step is that you file statement of objections and tell court, inform court, I am objecting to the extension on the face of it. So then what happens, generally, practically what happens, court will fix a date for written submission, and thereafter court will deliver the order whether granting interim injunction or not there. So then the other issue is in regard to the liquid claim. Now there are cases falling under the category of section 703, that is called checks, promissory note, bill of lading. There you have to understand the summons is the general, as far as the normal law is concerned. When a summons served, there is a specific returnable date given, and the summons says on the particular returnable date that if you do not appear, the case will be fixed for ex parte trial. That is the general summons. Now in terms of section 703, there is a particular under this format of 132, there is a specific summons. That summons says from the date of the service of this summons, within a period of 10 days that you have to come and get leave to appear and defend. In regard to liquid claim cases, for example, checks, pro notes, bill of lading, you can't get a date to file answer as a matter of right. What have you got to do? You have to file petition, affidavit, and necessary documentation to prove that you have a valid defense. Otherwise, in this instance, it's not ex parte. Straight away judgment will be entered. It is section 704 is very categorically stated there. So I'll just explain to you there. Section 704. All action where the claim is for a debt, liquidate damages in money arising upon bill of exchange, promissory note, check or instrument or contract in writing, liquidate amount of money or in guarantee where the claim again there. Then there is a prescribed form under form 19 of the first schedule. It says there. Then what happened? Section 704 subparagraph 1. In any case in which the plaint and summons are in such form respectively, defendant shall not appear or defend the action unless he obtain leave from court as herein before mentioned to appear defend. In default is obtaining such leave or appearance and defences in person that the plaintiff shall be entitled to decree any sum not exceeding a sum mentioned in the summons together with the interest is in there. So there are, once this under chapter 53 in terms of form 19, when a summons is served, the summons categorically states that from the date of the service of summons within a period of 10 days or 2 weeks that you have to reply. Now there are many instances where I come across many lawyers who, due to the ignorance, when a summons served under chapter 53, they don't observe this. They will check the record and say, no, there is a returnable date, we'll go and ask for a date. You can't. Because in terms of chapter 53, form number 19, you are not entitled to get a day as a matter of right. What have you got to do? You have to file petition, affidavit and supporting document and say you have a valid defense and therefore grant permission for me to file answer. Now there are 3 things court could do when you file papers. Number 1, if the court is fully satisfied, yes, now say for example some checks are issued, but if you can prove with certain correspondence by the plaintiff, those checks are issued on an understanding between the both parties as security, these are not given for a real consideration, then court can see, look, although you say this particular check was given on a particular transaction, it's not, it has been given on security and therefore it's a prima facie defense, I am giving full unconditional leave to file the answer. That is the first step. Second thing, court feels like 50-50. There is something what the plaintiff says. Yeah, there is something in what plaintiff says, also there is something in defendant says, and therefore I will give, okay, now say for example with the 10 million is the claim, if you want to file answer, deposit 5 million, then you can file answer. So that is the second step. The third step, court is not satisfied at all. If the court is not satisfied at all, then the court can turn back and say, look, there is no prima facie defense at all, and therefore I am entering, not giving anything at all, entering the judgment. There is no question at all there. So either court could say deposit full amount of money, part, or nothing. So 3 things can happen when you file papers for leave to appear and defend. Number 1, if the court is satisfied with the prima facie defense, court can say, yes, there is a prima facie defense has been established, no money to be paid, you are entitled to file answer. First step. Second thing, court say, look, I'm partly satisfied, not fully, and therefore deposit either 50% or 25% or 75%, whatever the percentage what the court feels thing. Third thing, court is fully satisfied. Court is not satisfied at all. Proceeding with the answer. So those are the 3 steps in terms of the liquid claim. Now the next step is, what will happen? 2 things. On the due date, or you having got leave, unconditional leave to deposit partial or whatever the money, you are not doing. So both are failures. Number 1 failure is that you were supposed to appear in court, you failed to appear. That's the first step. The second step is, you got leave under the conditional leave to deposit money, you failed to deposit. Then in both instances, section 704 subparagraph 1 will apply, but no ex parte, straight away judgment will be entered. There is no way at all, because these are liquid claims. For you to show cause, what will happen? The same thing will happen here. Judgment will be entered. So that is the procedure pertaining to liquid claims are there. Now, having gone through that, I like to deviate the thing to discuss with you in regard to the similar provisions I have come up with the 1 of 2023, the Recovery of Possession Premises Given on Lease Act number 1 of 2023. Now, earlier we had the law pertaining to this was Rent Act number 7 of 1972. At that time, the Rent Act was completely in favor of the tenant, completely in favor. And also, it was due to that, you see, I am personally aware, the tenants have taken a lot of advantage, and there are cases which has gone 10-15 years, and landlords couldn't get the fruit out of it, they have died. And similarly, there are instances where the tenants are very valuable property, paying even 100 rupees or less than that in a very heart of the town, they are staying as tenant, where the landlords or the owners are paying 40,000-50,000 rupees and living in a rented out house. And also I am aware there are premises even in Main Street, the well over premises occupied by a tenant in the heart of the town, Main Street area, they pay less than 100 rupees rent, but to vacate them, send them out of the premises, 50 million you have to pay. Extortion. So those laws are undoubtedly bad laws because that has been enacted far back from 1972, almost like well over 50 years ago. It's a bad law. It was completely in favor of the tenant. Those laws were enacted, and that's what we call famous saying, justice delayed, justice denied. So going to that old one, it was undoubtedly justice was delayed and therefore people suffered, justice denied. But having said that, now they have enacted, this is my personal opinion, I am not trying to cast any aspersion of anybody who drafted this legislation. My personal opinion is, this is the other side of that. It is, we say, justice delayed, justice denied. I am also with responsibility to say, justice hurried, justice buried. When you rush to do the justice, justice will be buried. What I am saying is whether it's how far you agree, that you will see when I discuss with you the salient features of this Recovery of Possession Act. Now this particular new act, I think this is the latest act there, for you to, any person, any tenant or any lessor to invoke the jurisdiction, the first and foremost thing that person has to do, there must be a lease agreement. And having said the lease agreement, it says very categorically, it has to be two things to have a valid lease. One is, it should be due execution. Number two, payment of stamp duty. So in terms of the, I'm discussing with you now, if you can take down, Recovery of Possession Premises Given on Lease Act number 1 of 2023 is the new law. So easy way to eject the tenant, this is the new law. So according to this law, section, it's very categorically, it says section 2 of this thing, two things have to be there. One is there must be a due execution of the lease, payment of stamp duty. So if in terms of the Prevention of Frauds Ordinance, section 2, if the notary has duly certified and witnesses have signed, that would suffice. Addition to that, payment of stamp duty. But the most crucial thing is, it is not mandatory to register the deed. As far as with my experience, any document to have a validity, it has to be registered in a relevant place. If it is a power of attorney, Registrar General. If it is a deed, it has to be in the Land Registry. Now, section 30, subparagraph A of the Notaries Amendment Act 31/2022 makes it mandatory. Now, cutting across that legislation, this particular law says registration is not mandatory. So that is the very reason I said is a hurried legislation. So that is one. The second thing is, I couldn't tell you earlier there, in regard to the jurisdiction, back again they have dealt. So the question arises, if you are suing on a lease under the Recovery of Possession Premises Given on Lease Act number 1 of 23, where you can file action. So there are various limbs are there. In terms of section 2, subparagraph 1 of the act, action could be instituted within the following jurisdiction. Number 1, where the premises given on lease is situated. Where the premises given on lease is situated. Number 2, where the lessee resides. Where the lessees reside. Next one, where the cause of action arose, where the lease agreement sought to be enforced was made. The rather somewhat a mixture of section 9 of the Civil Procedure Code. Now, having done that, next question is, at what stage the action could be instituted? According to section 3, subparagraph A, on 2 occasions you can file action. Number 1, lease period is over. Tenant is not going. Lease is over. Lessee is refusing, failing, or neglecting to leave the premises. You can file action. Second occasion, while the agreement is on, agreement is on. So first step I said was, agreement is yet in operation. He is refusing, failing, and neglecting to leave the premises. First step. Second step is, agreement is on, but he is not paying rent and refusing, failing, and neglecting to pay the rent, or he is breaching any conditions in the agreement. For example, he is subletting the premises, or he is converting the residential premises to a business premises, or using the premises for a illegal or immoral activity. So on 2 stages you can file action. What are the 2 stages? First stage is, lease period is over, is refusing to vacate. So basically, lease over, refusing, failing, and neglecting to leave the premises. That's the first step. Second step, lease is on, is not vacated, is not terminated, but he is not paying rent and not going, refusing, failing, or neglecting to pay the rent. And other thing is subletting the premises or converting the residence into a business premises. So that's a breach. So those 2 occasions you can file action. Then how do you file action, and what are the documents you need? So in this provision, where although it's a summary procedure, there is no petition here. You have to file action by way of an affidavit. So here the situation is, you file a petition, plaint, an affidavit, together with the thing you draft. There is no summons here. The difference is, there is no summons. What do? Draft decree nisi there. Then copies of the plain, affidavit, together with the documents what you are relying on there, and also, say for example, notice to quit, police statement, photograph, anything there. So I'll just go slowly. What are the documents to be filed? No petition, you need a plain. Together with the plain, there is no summons like in other cases. There is a nisi, draft decree nisi. Then your supporting document. What are your supporting document? Notice to quit, police statement, photograph, or any of the other document to support the plaintiff. Those are things has to be done. Now, there again, then question of affidavit. When you talk about affidavit, you have to be very cautious, because it says in terms of the oaths and affirmation ordinance, when a person is signing as a JP, he could not have any kind of a interest. Now, for example, if you are working in a firm, so if you are running a firm, you can't get your firm assistant to sign the affidavit. Why? He or she will have his interest, and therefore section 12(2) of the Oaths and Affirmation Ordinance very categorically states that when you have an interest in the thing, you can't do it. So specifically make a note, when you are preparing an affidavit, that affidavit should be sworn by a third party commissioner of oath, not one of your staff, not one of your subordinate with whom you are doing your work. And if his or her name appearing in the proxy, totally disqualified. There are enough instances where the actions had got dismissed. Now recently there was a political case where well over 66 applications of a political party. He is the particular person who has sworn the affidavit, he is the junior counsel in the case as well as he is the notary. The other side took up the objection because on the face of it you can see appearances marked so and so, a junior, this man's name was there. Similarly, when you look at the affidavit, his name is there. So the action got, 66 actions got dismissed. So in terms of section 12, subparagraph 2 of the Oaths and Affirmations Ordinance, if he or she has any interest in respect of the subject matter, should not sign as affidavit. Then specifically, as I said, there are again two cases I'll give it to you. Airport Aviation Services Sri Lanka Limited, Airport and Aviation Services Sri Lanka Limited versus Buildmart Lanka Private Limited. This is an old case, 2010 1 SLR 292. 2010 1 SLR 292. Second case is SC Special LA 99/2021. SC Special LA 99/2021. Mudian Selagi Arna Samantha Kumar versus TACN Talangama and 36 others. SC Special LA 99. So both these cases where court held that in terms of section 12 subparagraph 2, when you have any kind of interest under oath and affirmations ordinance, you are not entitled to sign affidavit there. Then similarly, when the affidavit is sworn in, you can't just say I am the affirmant or I am the deponent. You have to specifically say that paragraph. You look at section 181 of the Civil Procedure Code. I'll read. Affidavit shall be confined to the statement of such facts declarant is able to his own knowledge and observation to testify, except on an interlocutory application in which statement in his belief may be admitted, provided that reasonable ground for such belief set forth in the affidavit. So, as per section 181 of the Civil Procedure Code, person who is swear in the affidavit must state that he or she swear in the affidavit from his own personal knowledge or out of the information extracted from the books or records kept by him in the ordinary course of business or information there. So if you don't confine to section 181, your affidavit will be rejected. Then what will happen now, talking about the procedure? As I said, it's a very different type of a law there, this Act number 1 of 2023. Now I dealt with you the in regard to what is a lease agreement, jurisdiction, and also at what stage you can institute action, what are the documents. Now what happened? When you file action, when you don't know you file action, because these are, while I am saying there's certain thing bad, these are good action, good also there. In terms of section 4, subparagraph 3, upon filing an action within 7 days, that's a good move. Within 7 days, court should permit the plaintiff to support the decree license. It's good. That's a good one. So then what happened? As I told you, this decree license is very funny. This decree license is not a summons. It is basically a writ giving power to the fiscal to enter into the premises and take possession and recover the money. So it's a totally a different thing. So if you to the NISI, if you do not respond, absolute enter, then you will be thrown out of the premises there. So in what instance court will issue a decree NISI? In terms of section 5A subparagraph 2, if court is satisfied that the plaintiff in the plaint has a word ground satisfaction prima facie breach has been committed by the defendant, and also adduce proof if the document submitted by the plaintiff is not open to any suspicion, alteration, eraser, interpolation in the lease agreement, in such event court will allow the thing. So you file papers, court prima facie satisfied that documents are well in order, issue NISI. Court should also be satisfied that the content of the affidavit in such event will enter NISI and there. So as I said, I am repeating this word, it is not a summons. So no sooner you file the papers, within a period of 7 days, NISI will be issued. Basically, NISI is tell the fiscal, go to place, take over possession, and to do if the other side doesn't take steps within a stipulated period. Now I will just glance through a form of a NISI. Look at the wording in the NISI. Therefore, these are therefore to command the fiscal enter and have possession of the premises described in the schedule here to eject the above name, defendant, his servants, agents, those who are holding under him from the premises. Now this is the format of a NISI. Now having tendered the document, what kind of a relief court could grant? That is set out in section 5, subparagraph 2 of the thing says, arrears of lease. Now say you file basically like a normal okay, you file a put a lease and file an agreement. What are the relief that you can get? Arrears of lease rental, service charges, if any, there, then liquidated damages, interest on arrears of the lease rental, such costs there. Now, this particular section does not say that you can get enjoining order, but of course, understood, because that's what I said, the lacuna in the law here again, they should say the procedure pertaining to the civil procedure court will follow. So then that would happen. No such clause here. So according to this looks like only you can get damages, arrears of rent, service charges, those. But of course, you can definitely get the enjoining orders are there. So now, when you talk about the enjoining orders, now common, I think it's commonly known as this was a very useful cases for you to know. Seelavati Mallava versus Mili Karnaratna, 1982, 1 SLR 384. 1982, 1 SLR 384. Number 2, Subramaniam versus Sabdeen, 1984, 1 SLR 48. Now, in the first case, what happened now, there is in Kandy, there was a film hall given on rent to a tenant to occupy. So the lease period is over, the person refused to vacate. So the landlord went to court, filed action, very unusually, asked for a court order in the first instance itself to eject the tenant. And also to get went on the basis called a wrongdoer consent. It's a new one called wrongdoer consent to eject the tenant from the premises on the basis that he is occupying the premises illegally. So, court in the first instance quite correctly refused to grant the order of ejectment. Court said in the first instance court can't give the final order. Of course, gave an order restraining him carrying on any business at the premises. Then what happened is, that is, it's not set out in the civil procedure code. These are case laws where if a overholding lessee is continue to occupy the property, court identify that person as a wrongdoer. So court should not be a party to a wrongdoer. So in the Seelavati Mallava versus Mili Kirthiratna case, 1982 1 SLR 384, court held that if a person is illegally, wrongfully continuing the premises after the lease is over, he could be prevented from carrying on business. That is the first step. Then the second one is Subramaniam versus Sabdeen, 1984 1 SLR 48. Similarly, business premises in Kolpiti, where the lease is over, he is continuing. Landlord went to court, filed action, and court at this judgment. The lawyer who appeared for the defendant took up an objection and said that judgment has no relevancy because in that judgment, premises has been given on with the landlord's machinery. There is no such machinery here and therefore law is not applicable. Court overruled the objection and held the concept or the theory is a wrongdoer concept, whether it is given on rent with the equipment or no equipment is immaterial. So those are two matters are there. Then the next thing is, court in regard to this act, now I am dealing with that. Section 6 subparagraph 1 of the act, when determining the liquidation damages, court should not award any sum in excess of twice the lien. Now say for example, you have a lease agreement. According to the lease agreement, monthly rental is 50,000 a month. Then it says that if we do continue to occupy illegally, wrongfully, after the period is over, he will be liable to pay 150,000 a month. The section says no. If a person is overholding for after the lease is over, all what court can award is only another 50,000, not more than that. Basically, twice the amount. If it is 50,000, 100, not 150,000. That's what it says. As per section 6, subparagraph 1 of that, when determining the liquidated damages, court should not award any sum in excess twice the lease rental. For example, if monthly lease rental is 100,000 and liquidate damages set out in the agreement is 300,000 per month, in such event, court should grant maximum twice the lease rental, only 200,000, not 300,000. Then also in terms of section 6 subparagraph 2, if the parties have not agreed upon the liquidated damage payable in the lease agreement upon the default in such event, the grant only the monthly rental as liquidated damages. For example, if the monthly rental is 50,000, lease agreement doesn't mention in such occasion, only monthly rental should be deposited as damages there. Now you enter into a lease agreement says monthly rental is 50,000, there is no clause to the effect to say upon the expiry of the lease, if we do continue, how much to be paid. If there is no amount specified, when court is giving damages, it can give only the same amount, not a cent more, not a cent less, same amount. Then, as per section 7, court should not grant service charge unless the lease agreement specify and states that the service charge either directly paid to the plaintiff or the person on behalf of the plaintiff. So, in regard to service charge, these arises mainly in condominium. If the condominium says there is a service charges, maintenance charges, especially for the common area, then it has to be there. If there is nothing specified, then no. Then, upon entering the degree nisi in the first instance, ex parte, court will issue same to the fiscal to serve to the defendant to show court why the degree nisi so entered should not be made absolute. So now the degree nisi is entered, and having entered the degree nisi, serve to the defendant. It will say, give the time why the nisi should not be made absolute. As per section 8 subparagraph 2 of that, degree nisi ordinarily be served by the registered post at the premises given by the defendant there. Now this is a very dangerous clause. Now say for example, up to now, the law prevailing in Sri Lanka, specifically section 60 subparagraph 1, 60 subparagraph 1 very clearly says, now as at now the procedure is, if court is issuing summons, fiscal is going there, court is issuing summons in the first instance by registered post, other side doesn't turn up, court never fixes it to ex parte, court says no, serve personal. But here it's dangerous. Here it says registered post is sufficient. So if you get hold of a post officer, postman, or if you get hold of a person, say if it's a condominium property, the watcher, he can give it to his hand, case will go completely, judgment will be entered. As per section 8 subparagraph 2, the degree nisi ordinarily served by the registered post at the premises or at the premises given by the defendant. So according to this, there is no necessity to serve personal service. Registered post suffice. Need not be even served to a person. It can be served to the premises. And also it says address either given by the defendant or to the premises. That's a very dangerous provision because it can be lead into a lot of malpractice. Because if you look at now, in regard to all other cases not covered by this act, as per section 60 subparagraph 1 of Civil Procedure Code, if the summons served by the registered post, in the first instance, even if the defendant failed to appear, in such event summons should be served by personal service, and case will never fix record. So the law, not 1 of 2023, in regard to the other cases, if the summons is served by registered post, if they fail to come, never go for ex parte. Back again to be served personally, because court always recognize the personalized service. Here the danger is, now the personal service has been removed, it has been now made, you can do it by registered post. However, as per this act, it is not mandated to serve nisi through the personal service by the registered post would suffice. As per section 9 subparagraph 1, it states that court may, an application by a party could serve decree nisi to the defendant personally through personal service, if it is the discretion of the court to serve through the process server, but it is not mandated. Now back again, now as I said, summons will be served by registered post. Either you drop at the premises or given the address. There is no necessity to serve personal service. Back again, it violates the section 60 subparagraph 1 of the evidence ordinance. So you can't bring a legislation to violate a provision, mandated provision of another legislation. Earlier I said in regard to the registration of the lease agreement, section 30 subparagraph A, where registration is mandatory. But in terms of this law, no. There again, service of summons, section 60 subparagraph A says it has been served personally. This says no. It's a direction of court. This could be leading to malpractice. It is important to note, having entered the NISA, court shall within a period of 3 days. Now this time period is I really entertain, because at the moment when you file action, it takes 2-3 months to get the summons returnable date. Now these provisions are good, provided if it works properly. Now this says once the NISA is entered, fiscal can't drag on, within 3 days he has to serve. Now back again, service is what? He goes and dump into a place and come back. In case of a degree NISA, it be served out of the jurisdiction of court, steps should be taken within a period of 10 days from the date of the receipt declared. So if it is in Colombo, wherever the vicinity area where the court is situated, it is within a period of 3 days. If it is going outside Colombo, it is to within a period of within a period of 10 days. Then section 9 subparagraph 4, it says special process server could be permitted by the court to serve degree NISA outside. So even assume for a moment you have to serve summons in outstation, say Kadutara. Now we have filed action in Colombo. That also could be served from the Colombo fiscal, provided that you call a special process server. You have to get the code there. Now next one, section 9 subparagraph 5. When process server while serving the degree NISA, he must obtain signature or the thumb impression, or both from the defendant or any other person on his behalf. Now back again, in my personal view, these are redundant. Now you see, okay, getting the signature, I agree, good. Identity card number, signature, good. Next one is a thumb impression. So anybody can put a thumb impression. We are not sophisticated to ascertain whose thumb impression is. So if somebody doesn't sign, it says signature or thumb impression. So if a person doesn't sign, now say you can go to a condominium premises, get hold of a security person, now say it has to be served on X, you get the Y thumb impression. So how do you prove you gave it to X? No way to prove. Or any, and also the other danger is, or any other person on his behalf. So on behalf of the defendant, any other person also could take the NISA. This is much needed provision that has been introduced by Act. So in regard to signature, yes, I agree. Thumb impression is redundant, and also any other person serving is very dangerous. So back again to tell you, degree NISA need not be served personally. It can be dumped into a place and come. Then when a processor goes there, he just get the signature or thumb impression, or both. But then this is also redundant situation there. Then if the processor, section 9 subparagraph 9, if the process server couldn't serve the degree NISA, he could affix the same at the part of the premises without any further direction. Good. Now, fiscal goes to serve someone. He himself, he the judge, he himself decides, no, I can't serve personally. He will come and put a report and say, unable to serve there. He said, I am affixing. So, how do you know whether the fiscal will affix or not affix? So, if a fiscal, if you today corruption, I need not tell you, you know very well, if you get over a fiscal, you can pay any amount of money and get a degree NISA, it will be made absolute and you will be thrown out. It's a very, very dangerous law here. This section 2 could lead into disadvantage to the defendant, and there could be possibility that without even making any effort to serve the degree NISA through fiscal by persons without affixing the degree NISA, fiscal officer could submit a report to court stating that degree NISA was affixed and there is no intervention of the court for the need for substitute service. This could lead to the malpractice. There is a total disadvantage to the lessee. Wide power has been given to the process server, court has no there. So, to begin with, A, service of degree NISA, there is no necessity to serve personally. Registered posts suffice. Then also having served the registered post either to the premises, not to a person, to a premises or to the given address you can give it. Then if the fiscal decide that I can't serve, he himself will put a report. No sooner he put a report, he himself will say, no, I serve substitute service by affixing. Nobody to watch, no one to see. So these things could lead into malpractice. Even in regard to service of summon, thumb impression is good. But whose thumb impression? How do you see biometric? Who has signed and taken? You can't. By thumb impression and a signature both, yes, good. But then again he says he can serve it to any other person. So these new provisions can lead into massive malpractice. Now next step. Procedure regarding to granting leave time limit to show cause by the defendant. Now once you file papers, NISA entered, and if the NISA is served, the time limit is very prescribed. What is the time limit? Within a period of 6 weeks. You have to show cause within a period of 6 weeks, and no time could be granted, no further time. Now, even if you look at section 839 of the Civil Procedure Code, there is a discretion of court. There is no discretion here. Well, once a 6 weeks lapse, under whatever difficulty you have, it can be corona, it can be lockdown, anything, court can't do anything. Court powers are completely curtailed. So, upon a decree nisi being served, time period is 6 weeks, you have to file paper. And how do you file paper? You have to file petition, affidavit, and to show cause why the signature should not be made up. And court has no time. Time is completely curtailed. You have to file paper. No exceptional circumstance set out in the Act obtain more time. Now, even if you look at 839 also supersedes. Section 839 very categorically says powers of the court. Any extreme circumstance, court can use its discretion. No discretion. Then, as per section 12, subparagraph 2, defendant should file petition affidavit with the supporting document giving reason why court should grant leave. Then, whatever, assume for a moment, even if court is satisfied, that's another dangerous situation. Even if the court is satisfied, court will not grant leave unless the entire security deposited. Now, say for example, you are in arrears of rent, running into say 10 million. You have to deposit the entire 10 million if you want to file answer. You can't otherwise. You see, it's very dangerous situation. So, number one, you have to file petition and affidavit to show court why court should grant permission to get the leave. Even if you are satisfied court, even if you get the thing at all, court says no, my hands are tied, you have to provide so much of security. Otherwise, absolute will be made. Then, if the court is not satisfied with the contents of the petition, affidavit, same is not disclosing a prima facie case, then the court will make the absolute. So, if you are filing papers, if the court is not satisfied that you have not made a prima facie case, then court will enter the decree absolute. Then, when court grant leave to appear to show cause in such event, court shall order a sum due to the plaintiff aggregated arrears. So, as I said earlier, now court is satisfied in regard to your leave, in regard to your defense. Then court says, yes, I am granting leave, but deposit the entire amount of money if you want to file answer. Otherwise, absolute will be entered. In terms of section, aggregate sum due to the plaintiff as service charge, everything will be included, whatever the liquidated damages, everything will be included. Now, when court satisfied and say, first and foremost, upon the service of the summons, within 6 weeks you have to reply. Now, within 6 weeks you are now filing petition, affidavit and trying to show court. Now, court saying deposit security. So, when court says deposit security, you have to deposit security within a period of 2 weeks. No more time. In case you are in a real difficulty, court will grant further 2 weeks, that is from the date of the previous 2 weeks. Maximum you can get only 4 weeks, not more than that. Court's hands are totally tight. Even court sympathize with you. Court will turn back and say, yes, I feel sorry for you. I can't tell it, my hands are tight. Then, upon the expiry, court, you don't deposit the money. Then, even if you take, as I said earlier, liquid claim, section 703, there again, you have to get leave to appear and defend. When you get leave to appear and defend, if the court is satisfied that you have a sufficient ground to show cause to get leave, court always allow unconditional leave. There is no unconditional leave here. Then, results of the failure to appear in court or fail to deposit security. If the section 15, if the defendant fails to make an application to leave, appear and show cause on the specified day. First step is, you fail to appear to show cause. Number 2, having made application to leave and show cause, fail to disclose a prima facie case. Or you got the leave, security you can't deposit. So there are 3 instances section 15 talking about. Number 1, having received the nisi, you don't appear. That's the first default. Second thing, you fail to establish a prima facie defense. You can't. Third one, security order, you couldn't pay the security. Then in such event, without any further notice to the defendant, court will enter nisi to be made absolute, provided however, that if a party, they can amicably settle, otherwise settle them. Now, even if you look at, take the, for example, section 86 subparagraph 2 of the Civil Procedure Code, say summons has been served, you are out of the country, all what you have to do is you come and show the passport, nice ex parte judgment will be vacated, get a date to file up. Now, in this instant, assume for a moment, decree nisi was served, said to be served, and you come back and say, no, I was in such and such a country at the time of the service of decree nisi, nothing can be done. Now, look at Ainari, what a dangerous situation there. Assume for a moment some fraudulent act happened, you are out of the country, papers have been served. So when you come and show your passport, still no mercy, because no fault of yours. I don't understand why a fraudster should be allowed to get the benefit out of that. Because if a person is out of the country, if a person comes and says, here is my passport, I was not in the country at the time of this so-called nisi has been served, here is the document. Court says, yes, all that is correct, you have a very good defense, because papers have not been served, but deposit that man's entire money if you want to fight. I don't understand the justice. Then, plaintiff's claim after the institution of the action and upon entering the nisi. Now, this is a situation where nisi is entered, absolute entered, person got thrown away from the premises. After he leaves the premises, landlord discovers he has electricity bill, water bill, rates and tax, so many things are there. Back again he can make an application by way of a petition affidavit where the court will enter nisi back again for him to make the payment. Now, next step is, next question is there, whether this act is retrospective. So now this law came in operation on 1 of 2023 this year. Whether this is applicable to the lease which has been entered prior to that, prior to 2023, and leases which have been lapsed. So this is what the section says. Section 31 subparagraph 1 of that, this act could be invoked in regard to the lease agreement which was executed prior to the commencement of this act, and furthermore this act also apply in regard to the lease agreement which has been expired, terminated or prior to the commencement of this act. So basically this particular law will be good or applicable even leases done prior to this, or it has been expired or terminated prior to the commencement time. Not only that, it goes a step further. Assume for a moment you have already filed the action against a holding lessee. You are finding it difficult to eject him. You can withdraw that action, file a fresh action, get the relief. I think once you get hold of a fiscal officer, you can get the relief very quickly. Then, as per section 34 of this act, rent act will not apply there. Now, what steps to be taken when the leave being granted? When court grant leave to appear and show cause against an nisi to be the defendant, security or deposit within stipulated period, the show cause there. Then, of course, as section 384, 385, 386, the normal procedure will apply. Then, in terms of section 17 subparagraph 2, so cases of this nature, who should start the case is the defendant, not the plaintiff, because a person who has to show cause is the defendant. Then, in regard, once a nisi made absolute, it will be applicable, it will be valid for a period of 1 year. And once a nisi is issued, one of the two things can happen. Either decree nisi can be discharged or decree nisi can be made absolute. And also when the trial commences, court has a power to call for the original lease agreement, but they won't keep, they'll return. Now, what instances compensation will be awarded? After entering nisi, if court satisfy that they have obtained the nisi by willful suppression or non-disclosure of the fact, and then at such instant, decree nisi can be discharged and also action can be dismissed there. Then also it says court may in same action on the application filed by the defendant against whom the nisi was entered award compensation cost. So if a case is got dismissed or got a absolute entered in wrongfully, in such instant court can award damages. But if the court award damages and grant relief to the either party, that again in regard to the same lease agreement, you can't file action because that will apply like a res judicata, you can't do. But however, without awarding any kind of damages or compensation, if a case gets discharged or degree nisi be made dismissed, then still you can file case. Now, as we are running out of the time, I'll run through quickly the procedure. Now, next step is, if you are not satisfied with the order given by court, you can appeal to the Civil Appeal High Court. Then what happened? You couple of things you can tell Civil Appeal. Number one, when you are appealing, defendant was prevented from appearing in court after the degree nisi is served by recent accident, misfortune or there. So, due to the force majeure, due to the God's act, you couldn't do that, you can do that. Next thing is that you can say nisi was never served on you. So, those are two occasions where you can go to court and say nisi was served on me due to whatever the reason beyond my control, I could not come. Accident or misfortune or some, as what the country turmoil we went through last year, due to that reason you have to say. Or you have to say summons was never served on you. That's the second, not summon decree. When an application is made to Civil Appeal Court to set aside the decree absolute on any one of those grounds, in such event the petitioner also should satisfy court ground to leave to appear a defense, namely petitioner specifically clearly set out. So why he could not come, those grounds has to be proved. So having been satisfied, if the court satisfied, court will definitely give an opportunity for him to put forward his defense. But back again, there is a specific clause to the effect to say that court can't give ex parte order. Now back again, this is a very serious situation. Now Civil Appeal High Court has no power, cases of this nature, to grant ex parte stay order. Now even if you look at Supreme Court rules, even if you look at Appeal Court rule, it specifically states that in the necessity, when there is a real necessity, ex parte stay orders are possible. But in terms of this law, courts, even not only the district court hands are tied, even the Civil Appeal High Court hands are tied. Court can't give ex parte stay orders are there. Then it says, even if the now say for example, that's what I said, matters related to all other cases, if the defendant could prove that the summons were not served and there would be no necessity to prove such sustainable defense, ex parte. Now, for example, as I said earlier, a person is out of the country. So he comes and produced a passport and says summons was not served. And he goes to a court of appeal and say, look, I could not come before court, but the reason beyond my control because I was in such and such a country. Here is my passport. There is nothing further to prove. But in a case of that nature too, he has to give the deposit. It's very unfair, but that's the law of the land. Then, if the Civil Appeal High Court is satisfied that the defendant could not make his appearance due to the matters set out above, also disclose a prima facie defense, in such situation, degree absolute entry will be vacated only upon the subject of security. So, even if you establish a prima facie defense, even in the Court of Appeal, it will be only vacated provided if you put a security. If the defendant failed to satisfy court that the defendant is prevented from appearing court also due to the force majeure or degree nisi is not served, or if the defendant failed to establish prima facie sustainable defense, then the Civil Appeal High Court will make application will be dismissed. Then next step is in regard to the procedure pertaining to the execution of writ. So when the writ is executed, when the nisi being issued and also made absolute, to giving opportunity to the other side to appeal for a period of 14 days, the writ will not be executed. It says section 22 subparagraph 1, when a degree nisi is made absolute, it shall deem to be valid, it will be a writ issued to their fiscal, but however, same to be executed 14 days after the date of the order making a degree absolute. Then by granting 14 days time, an opportunity has been given to the dissatisfied party to appeal to the Civil Appeal High Court to obtain a stay order. Then also it says, as per section 22 subparagraph, preferring an appeal. So you, just because of you filed an appeal in the Civil Appeal High Court to stay the proceeding, it doesn't make any kind of a thing. You have to obtain a stay order and then. So similarly, if an order is given by the Civil Appeal High Court, either allowing or disallowing the appeal, no steps will be taken for a period of 42 days. Why? To giving opportunity other party to appeal against the order. I hope time is over. Thank you very much for your kind patience.
Sir, there's a question.
Sure.
What is the prescription period regarding a violation related to disclosing confidential information against the employment contract agreement?
Sorry, I didn't follow the question.
What is the prescription period regarding violations related to the disclosing confidential information against the employment contract agreement?
No, that's again, it comes under the written contract, no? No, whatever the nature of the agreement, as long as it falls, question is there whether it's an oral contract or written contract.
And he is asking that if the employee had resigned before filing the case, he was asking that the question is related to that. Mr. Nuwan, if you can ask, but we are not clear about your question, so you can ask directly. Unmute yourself. And I have to tell you, the sir is very fluent in it's actually thorough in all three languages. If you want to ask the question, and you can ask even Sinhala, Tamil or English, whatever it is, sir, even though sir is Tamil and he studied everything in Sinhala, it's open to you all.
I'll be more comfortable in Sinhala and English. Any questions, please? I don't think anything, Prabha.
Yes, sir. And so on behalf of the Bar Association of Sri Lanka, I would like to thank you very much for delivering the lecture as per our request. Despite your heavy workload, thank you so much, sir.
Thank you.
I'm sure the participants would have received full knowledge from your excellent and detailed lecture. We will see you all next week with an interesting topic called conveyancing. To deliver this lecture, Mrs. Paralegal Activists will join us next week. Thank you to everyone and good evening.
Thank you very much, Prabha, for inviting me. Thank you.